Good evening, everyone.
Good evening.
Good evening all. I, Chaitanya Bansal, on behalf of Team Corporate Law Advisor and CII, welcome you all to our today's session on live channel corporate on ADR laws. In today's session, our experts will discuss the judgments delivered by the Honorable Apex Court and the High Courts, followed by a panel discussion on should Indian companies select foreign seats of arbitration. The session shall be moderated by Vishwam Sir, who is an advocate and an expert in arbitration, online dispute resolution, and other forms of alternate dispute resolution. Before we begin with the session, I would like to request all participants to please be on mute. During the session, if any participant has any query, feel free to post it in the chat box and they will be duly answered. With these words, I now hand over the dais to Vishwam Sir. Thank you.
Thank you, Chaitanya. Good evening, everybody. I hope everyone is staying safe and well. And welcome to the June edition of the webinar. If you've been attending our previous sessions, you would know that we have a monthly session on arbitration, mediation, and online dispute resolution. So without any further ado, I will just get started and share my screen. So for those of you who are not familiar, essentially the session is going to be divided in two parts. There's an update session where I would essentially cover the latest decisions in the world of arbitration and mediation by the Supreme Court and High Courts. And then there is a panel discussion thereafter, like Chaitanya said, where we'll be discussing the topic whether Indian companies can select foreign seats of arbitration and how that would play out. For those of you who attended the last webinar in May, we discussed the Supreme Court decision in the GE matter in detail, and I'll touch upon it very briefly when I start the panel discussion, but essentially that's going to be the focus point of today's panel discussion. So coming to the first part, updates, we've got 6 decisions today, a mix of Supreme Court and High Court decisions, like you can see. I think historically we've covered mostly Supreme Court decisions, but I think this time we've got some important decisions of the High Courts, which we didn't cover earlier, so we're covering them now. And just a housekeeping matter, sorry. If you've got any questions on any of the decisions, probably best if we discuss those questions as I go along them, instead of waiting till the end. And it'll be sort of an open discussion, so if anyone has questions, if anybody has any answers, any experience they would like to share, it's going to be learning experience for all of us. So the first decision, it's been in the news for a while actually, the Delhi High Court decision in Hero Electric Vehicles versus Electroe E-Mobility Limited. So the factual situation was basically there were sort of plaintiffs and defendants which would belong to the sort of Hero family. And historically they had entered into 2 agreements. There was a family settlement agreement, which basically enacted a partnership form and that designated the rights of businesses for each member group. So there were 4 sort of divisions, F1, F2, F3, and F4. And they also entered into a trademark and name agreement, which assigned the rights to use the registered Hero trademark and various variants of the Hero trademark. Both these agreements, so the FSA and the TMNA, contain arbitration clauses. And historically, before this case in the Delhi High Court, there was a previous arbitration between the parties, which had an award in December 2018, which determined the extent of rights accorded under the agreements. Now, in this case, what happened was basically the defendant tried to use the trademark Hero for the electric bicycles, and there was a dispute between under the FSA and the TMNA between the parties. So the plaintiffs in this case was basically F1 parties, which comprised of Hero Electric Vehicles and Hero Exports, and the defendant was F4, which was F1, F2, F3, F4. Which was Electroe E-Mobility and Hero Cycles Limited. Sorry, if you could keep yourself on mute unless you have a question. Thank you. So a suit was filed in the Delhi High Court for a permanent injunction, restraining the defendants from infringing and passing off a trademark. And the defendants filed a Section 8 application saying that the dispute should be referred to arbitration. So quickly looking at what the submissions were of the parties. From the plaintiff side, they basically said that the defendant's challenge is essentially so they're challenging the registration of the trademark, which would operate as a right in rem, so it's not arbitrable. Now, for those of you who attended the previous webinars, we discussed right in rem, right in personam, and how and what is arbitrable and not in detail in the January and February edition, where we discussed the Supreme Court decision in Vidyadrolia and the history behind Vidyadrolia. So the plaintiff's submission was that because it's all about the registration of trademark, the rights are in rem, so they're not arbitrable. And they go on to basically say that, the rights are not subordinate in rem rights to in personam. So it's not about the determination of designation of rights under the TMNA. It's about right in rem more generally. And the plaintiff also argued that, if it's all about infringement of trademarks, then you have to go under Section 28 and 29 of the Trademark Act. And Section 134 basically confers exclusive jurisdiction on the civil courts. And you need to go to the trademark registry, for instance. The defendants, on the other hand, argued that it's an action in personam. There's nothing about in rem here. Plaintiffs are just dressing up the suit to avoid an arbitration clause. And the dispute essentially arises out of and in connection with the FSA and the TMNA, which is how the dispute clause was worded. And the defendant also argued that, subordinate rights in personam emanate from the rights in rem. So it's basically a determination of designation of rights under the TMNA, which was the trademark agreement. The High Court basically agreed with the defendant. And I'm going to read out the relevant parts, but basically the High Court said that the issue in dispute was about the right of the mark under the agreements. It wasn't about passing off. It wasn't about trademark infringement. It wasn't about deceptive similarity. So it was essentially just a right to use the mark, which is basically an issue of contractual arrangements between the parties. And they basically referred the dispute to arbitration. But if I look at the relevant parts, I'm going to read each one of them to you, which is also on screen. In the first part, the Delhi High Court said the scope of examination by the court exercise jurisdiction under Section 8 on Section 11 is very prima facie in nature. Now, basically, we're going to discuss more about Section 11 later when I discuss other decisions. But the court basically said that you can't really go into the details. You just have to have a very prima facie view on whether there is an arbitration clause or not when you look at Section 8 and Section 11. In the second part, the court said, unless there is a clear case of non-existence of a valid arbitration agreement or of the dispute being ex facie non-arbitrable, tested on the above parameters, the court should leave these aspects to be decided by a competently constituted arbitral tribunal. Relegation of arbitration should be regarded as a rule and resolution by the civil court, where a valid arbitration agreement exists and is sought to be invoked by one of the parties as an exception. The expression chalk and cheese situation, and I'll come to that later, as used by this court has in this background been approved by the Supreme Court. When in doubt, says Ramana Justice in his concurring opinion, refer. Having said that, the doubt in my view has to be real and substantial and not merely an escape route to avoid examining the issue in perspective. The third point basically deals with the chalk and cheese situation, which was what the Delhi High Court said, is that if the situation is basically in black and white, that there is no arbitration clause, then by exercising powers under Section 11 or 8 of the Arbitration Act, you can say that the party should not be referred to arbitration. But if it's not if it's not black and white, if there are shades of gray, then there is no chalk and cheese situation, and basically you refer the parties to arbitration. So this was the decision of the Delhi High Court in Hero Electric Vehicles. It obviously concerns some intellectual property law as well. So I think that's the end of the first decision. If there are any questions, we can discuss them now before we move on. And feel free to put your question in the chat box or just unmute and ask. Okay. So the next decision is the Indus Biotech versus Kotak India Venture Offshore Fund. This is a Supreme Court decision issued in March 2021. Basically, the dispute was about payment and non-payment of debt between the parties. And the respondent had initiated proceedings under Section 7 of the Insolvency and Bankruptcy Code. When the respondent initiated proceedings, the petitioner filed a Section 8 arbitration conciliation application to refer the parties to arbitration before the NCLT. The NCLT allowed the application and referred to arbitration, but let's look at what the parties submitted before the NCLT because that's quite relevant. So the Kotak India Venture Offshore Funds case was that existence of an arbitration clause is irrelevant and not a factor which affects these proceedings under Section 7. Section 7 deals with the subject matter of insolvency, which is non-arbitrable and essentially in rem. And basically non-payment is default in payment of, non-payment is default in payment of debt. So NCLT should basically admit the application under Section 7. So in summary, Kotak's case is basically that Section 8 is irrelevant. These are Section 7 proceedings, the proceedings in rem, and all that NCLT has to decide is whether Section 7 applies, so whether there is a debt or whether there is no debt. Indus Response is basically that, the dispute is about valuation of Kotak securities, which is essentially an arbitrable matter. Now, Indus is also debt-free. It's a profitable company and not in need of a corporate insolvency process. And basically, investment by Kotak was in the share capital of Indus by preference shares. So Kotak is not a financial creditor. The NCLT, I think, was pretty much swayed by the fact that, Indus is a solvent, debt-free and profitable company. And pushing a solvent company into insolvency is not meaningful or desirable for anybody. So, because the dispute is essentially about Kotak securities, it referred the parties to arbitration. So essentially, there was an appeal. There was an SLP filed to the Supreme Court directly by Kotak against the NCLT order. And along with that, in parallel, there was a petition pending by Indus under Section 11 of the Arbitration Act for appointment of a tribunal. So basically, the Supreme Court dealt with both of these cases together, the one filed by Kotak and the one by Indus. And the Supreme Court firstly said that Indus overrides all laws. So if you look at Section 238 of the IBC, it basically says it overrides all laws. It doesn't matter whether it's the Arbitration Act or not. And it says mere filing of an application under Section 7 of the IBC does not make the proceedings in rem, whereas it does become rem on the date of the admission. So I think this is probably one of the key takeaways from this decision is that proceedings will become in rem only after a Section 7 application has been admitted by the NCLT. Until the date of the admission, it will remain in personam. And if an application under Section 8 is pending in a Section 7 application, when the Section 7 application is not admitted, the NCLT should first decide Section 7 application and is certain if there is a debt or if there is any default by the financial creditor. So basically the Supreme Court said you can't just file a Section 8 application under the Arbitration Act before an NCLT to delay the IBC process. And there should not be any independent consideration of Section 8 of the Arbitration Act application behoes the Section 7 IBC application. And lastly, the Supreme Court said if NCLT considers the debt due and admits Section 7 application, then basically Section 8 arbitration application is irrelevant. So the conclusion of the sort of Supreme Court decision ultimately is that it read the NCLT decision backwards and it said it was fine to refer the parties to arbitration because the NCLT could not conclude that there was a default under Section 7. But I think a point of discussion here, and my personal take is that the Supreme Court didn't clarify exactly how it would work. But if there's anyone on the panel who wants to share any experience or thoughts, I think one of the points of discussion is that if NCLT considers debt to be not due and Section 7 IBC application is not admitted, then should it decide Section 8 application? Because essentially at the point where the NCLT says Section 7 application is not admitted, would it not terminate the main proceedings? And if that would happen, then why should the NCLT decide a Section 8 arbitration application? Does anybody want to share any of their experiences, or if you have any questions on this decision, we can take that up now. No, I mean, it's an open discussion, like some of you would know who attended previous webinars. Any thoughts from anybody? Okay, I'll move on to the next decision. So the next decision is also a Supreme Court decision. decided on the 6th of April, and the case was Sanjeev Prakash versus Seema Kukreja. The facts were basically that ANI Media Private Limited was a jointly owned company by the Prakash family, and son and father petitioners here, and the mother and daughter respondents. So essentially, historically, the son sort of built or developed or took ANI Media to heights, and Reuters, the international media company, bought 49% equity shares in ANI. So historically, in 1996, the family members had entered into a memorandum of understanding, and that MOU had an arbitration clause, which basically gave the son a right of first purchase in the event shares were transferred between family members. Subsequent to the MOU, a shareholders agreement was executed between the Prakash family and Reuters, also in 1996. Now, the dispute arose when the father decided to transfer his shareholding to be jointly held between the father and the son, and the mother did the same between the mother and the daughter. So then thereafter, a notice invoking arbitration clause was served by Sanjeev Prakash, alleging that his preemptive right to purchase the mother's shares had been breached. The respondents, which is the mother and the daughter, alleged that the MOU ceased to exist because there was a shareholders agreement. The case first went to Delhi High Court under Section 11, and the Delhi High Court basically said that the law is well settled. If there is a novation of the agreement, then that novation essentially destroys the arbitration clause. So if I just going to read out the relevant paragraph, the Delhi High Court said, the law relating to the effect of novation of contract containing an arbitration agreement or clause is well settled. An arbitration agreement, being a creation of an agreement, may be destroyed by agreement. That is to say, if the contract is superseded by another, the arbitration clause, being a component or part of the earlier contract, falls with it. Or if the original contract is entirely put to an end, the arbitration clause, which is a part of it, also perishes along with it. So the Supreme Court then basically, the case went up to the Supreme Court from the Delhi High Court. And the court basically again relied on the Vidya Drolia judgment and basically said that the court is not empowered to basically determine whether an arbitration is in existence or not. So for those of you who attended the earlier webinars, we've discussed, how there is a distinction sometimes drawn between existence of an arbitration agreement and when it simply exists. So based on the Vidya Drolia judgment, the Supreme Court said that for Section 11 court to decide any matter, the existence of an arbitration agreement is mandatory. Whether or not the arbitration agreement actually exists or subsists is a question for the tribunal. So I'm going to read out the relevant part on novation, but basically the Supreme Court said that we can just look at whether it's prima facie or not. We can't really go into the details on whether there has been a novation or not and what the rights of the parties are, and then decide if the arbitration clause exists or not. That's something which falls in the domain of the arbitrator. So the Supreme Court said, and I'll read the relevant part, whether the MOU has been novated by the shareholders agreement dated 12th of April 96 requires a detailed consideration of the clauses of the two agreements, together with surrounding circumstances in which these agreements were entered into, and a full consideration of the law on the subject. None of this can be done given the limited jurisdiction of a court under Section 11 of the Arbitration Act. So basically the Supreme Court said, as long as the subject is arbitrable, the court pretty much should appoint an arbitrator. And this was a case where the disputed issues did not oust arbitration altogether. So it was not about a question on right and rem, for instance, where the Supreme Court needs to look at it a little more carefully. All it's about is whether there is a novation or not, and whether the arbitration subsists or not. So basically the Supreme Court said, let the arbitrators decide that. So that's the end of this decision. Any questions, comments, thoughts on this decision? Okay, very well. So the next is again a Delhi High Court decision. It was the Shapur Panunji and Company versus Ratan India Power Limited decision. Essentially, this is about the group of sort of companies doctrine. But very quickly, there are two respondents. Respondent one is a holding company and respondent two is a wholly owned subsidiary. The wholly owned subsidiary respondent two entered into 4 contracts for the construction of power plant with the petitioner. Basically, there were disputes which arose between the petitioner and the respondent 2, but it also included the holding company, which is respondent number 1. And the respondents basically refused the existence of an arbitration agreement between the parent company and the petitioner. So the arguments were basically that, the petitioner said the parties conducted themselves in a manner so as to accept arbitration as a one-step method for resolving disputes. And it did not make commercial sense for the parties to agree to refer disputes regarding the main contract to arbitration and not include disputes regarding the other contracts also in the arbitration. The respondent, on the other hand, said, the notice invoking arbitration is invalid because they're 4 separate contracts, etc. And obviously, respondent number 1, which is the holding company, argued that it was not a signatory to the arbitration agreement. The Delhi High Court basically looked at various cases on the group of companies doctrine, and it said the court decided that cases where third-party beneficiaries of a contract may be compelled to arbitrate using the group of companies doctrine. So I'm going to read the relevant paragraph, which is also basically the test to decide whether a non-signatory to an arbitration can be subject to arbitration. So the court relied on the decision in Mahanagar Telephone Nigam Limited versus Canara Bank and held the circumstances in which the group of companies doctrine could be invoked to bind a non-signatory affiliate of a parent company or inclusion of a third party to an arbitration if there is a direct relationship between the party which is a signatory to the arbitration agreement, direct commonality of the subject matter, the composite nature of the transaction between the parties. Composite transaction refers to a transaction which is interlinked in nature, or where performance of the agreement may not be feasible without the aid, execution, and performance of the supplementary ancillary agreement for achieving the common object and collectively having a bearing on the dispute. So basically, because the respondent was directly involved in the contract, the Delhi High Court said that it will have to arbitrate along with its wholly owned subsidiary respondent number 2. And this was basically because respondent number 1, which is the parent company, would have been a direct beneficiary. I guess one takeaway here is if the beneficiary was indirect, so if respondent, which is not a signatory to the agreement, it's an indirect beneficiary, then this decision, including the decision in Mahanagar Telephone Nigam, wouldn't apply. So you could still argue that if you're an indirect beneficiary, you cannot be compelled to arbitrate. This decision, an SLP was filed to the Supreme Court, but it was withdrawn about 10 days ago. So it's been referred to arbitration basically now. Sorry, that's the end of this decision. Any questions from the audience? Any comments? Any thoughts? Okay. The next decision is quite interesting. It's from the Bombay High Court in Bay Capital Advisors versus ILNFS Financial Services. So I've used the term IFIN for ILNFS Financial Services here. The background is that the petitioner provided a security for loan and basically couldn't repay. The debt was also restructured, but again, it could not repay. A petition under Section 9 of the Arbitration Act was filed seeking tenant protection, which restrains IFIN from acting under its event of default notice and also from a pledge invocation notice which was served. In October of 2018, so this is going slightly before the notices were sent out by IFIN, the NCLAT, which is the National Company Law Appellate Tribunal, under Section 241 and 242 of the Companies Act, had stayed the institution and continuation of proceedings before any court of law, tribunal, arbitration panel, or arbitration authority. And this order was basically issued in larger interest. So the petitioner basically said that NCLAT could not have passed the order, which it did in October 2018, as it is not a tribunal or a judicial authority empowered to issue a high prerogative remedy. It said it is not a constitutional court. Whatever be the wording of sections 241 and 242 of the Companies Act, they do not give the NCLAT a power of superintendence of other courts, and most emphatically not over the courts that are neither subordinate to the NCLAT nor subject to its superintendence. And the petitioner also argued that NCLAT's order was basically per incuriam. It was also against Section 41B of the Specific Relief Act, because Specific Relief Act said anybody can apply for an injunction to exercise the rights. And they basically heavily relied on the Supreme Court decision in Cotton Corporation of India versus United Industrial Bank to say that firstly, it's against specifically fact, and secondly, unhindered access to justice is a right accorded by law. The Bombay High Court essentially agreed with the petitioner, and it said the NCLT has done something that it cannot possibly have done. I'm going to read the relevant paragraph, I think, because it's quite interesting. The Bombay High Court said, when it used the word... Hi, sorry, does anyone have a question?
No, sir.
Okay. So the court said, when it used the words any court of law, this could conceivably mean the High Court as well. The NCLT has absolutely no jurisdiction over this court, even on its original side, given that this is the chartered High Court. The High Court is in no way subject to the NCLT's jurisdiction or superintendence. I do not see how the words court of law can be read down, because other than the NCLT, there is no other judicial authority over which the NCLT exercises such superintending power. But if we leave that aside and focus on the words arbitration panel and arbitration authority, and even assuming for a moment that the NCLT has the power to stay arbitrations, it certainly does not have the authority to stay the hands of this court in hearing a petition under Section 9 or any other petition that properly comes before this court under the Arbitration Act. Indeed, I do not even see how the NCLT has such control over arbitration tribunals. The NCLT can make no order under Section 9, 11, 34, 37, or any other provisions of the Arbitration Act. Notably, Section 9 of the Arbitration Act, and indeed no provision of the Act, is made subject to the Companies Act. So basically, the Bombay High Court said that NCLT has passed this order, but it can't really do so because it doesn't have jurisdiction over any court other than the NCLT. So basically, the court said that this petition is maintainable. It's a different thing that when it actually went on to decide whether Section 9 relief should be given to the petitioner or not, it decided against it. So there was no Section 9 relief ordered by the High Court, but it did in fact say that this was admissible and we're not really bound by the NCLT order, which was passed in October 2018. So that's the end of this decision. Any questions, any comments, any thoughts? Okay. So that's the sixth and the last decision before we move on to the panel discussion. This was a Calcutta High Court decision issued recently. And the facts are pretty simple. So the petitioner is an award debtor, which filed an application to set aside the award under Section 34 of the Arbitration Act. And during the pendency of these proceedings, the NCLT approved a resolution plan placing the management of the petitioner into a new entity pursuant to the IBC. The issue was basically whether the claim of an award holder can be frustrated on the approval of a resolution plan under Section 31 of the IBC. The petitioners argued that the proceedings are infructuous now, as the resolution plan extinguishes all debts and claims. And basically, the resolution plan just creates a new management now, so the debt is not owed by the new group. And the respondent should have basically petitioned the NCLT to include the debt from the award in the plan. The respondent said, well, the petitioner company basically continues to exist, so its obligations under the award must remain in place. The High Court basically just entirely relied upon the decision of the Supreme Court in the SR Steel versus Satish Kumar Gupta case. Basically said, because the IBC proceedings supersede, the award is basically extinguished now and you can't really go after the new management. So that's the end of this decision. Any questions on this decision? No. I'm going to go back to just the slide which has all 6 decisions. Any questions on any of the decisions before we move on to the panel discussion? Okay, we can move on to the panel discussion now. So we've got a very interesting and a very eminent panel lined up for today to discuss should Indian companies select foreign seats of arbitration and how we expect that to play out. If I could request Chaitanya to just introduce our eminent panel members for today.
Yes, sir. Thank you. So our today's panel is composed of Pramod Nair, sir, and Shineen Parekh, ma'am. Welcome, sir. Welcome, ma'am. Pramod sir is a law graduate from NLS Bangalore and a postgraduate from University of Cambridge. He has conducted various arbitrations in various jurisdictions, including Europe and Asia. He has also acted as an arbitrator in various arbitration centers like LCIA, SIAC, and HKIAC. He has been recognized as a leading arbitration practitioner by Global Arbitration Review. Shaneen ma'am is a partner in dispute resolution team at Mumbai office of Cyril Amarchand Mangaldas. She has conducted various arbitrations and has represented her clients before various regulatory forums and courts across the country. Her main focus is on arbitration, both at international and domestic level. She has also assisted a leading commerce chamber in drafting the rules of arbitration, mediation, and conciliation. And she has also served as an ambassador in Asia Pacific Arbitration Group of International Bar Association. Besides that, she has received recognition from reputed organizations like Who's Who Legal, Asia Law, etc. I hand over the dice to Vishwam. Thank you.
Thank you, Chaitanya. I think before we move on to the sort of panel discussion and free-flowing discussion, for those of you who are not familiar with the background and you didn't attend the May edition of our webinar, I'm just going to quickly run over through the Supreme Court decision, which is basically going to be the background to this discussion. I won't discuss this in as detail as we did in our last webinar, but just very quickly. So the key decision, I think, here is the Supreme Court decision of PES Elwyn Solutions versus GE Power, where basically both companies were incorporated in India, and the dispute was essentially under a contract relating to converters. The arbitration clause provided for ICC arbitration seated in Zurich, but under Indian law. So basically, essentially, there was the arbitration proceedings went on. In the end, the arbitration panel ordered the appellant to pay about 2.6 crores plus $40,000 as costs and expenses to the respondent. The respondent then commenced execution proceedings under sections 47 and 9 of the Arbitration Act. The Gujarat High Court held that Indian parties can choose a foreign seat, and then this came to the Supreme Court. The Supreme Court is essentially deciding on two issues. The first issue is whether two companies in India can choose a forum for arbitration outside India. And secondly, whether an award made outside of India, to which the New York Convention applies, is considered as a foreign award under Part 2 of the Act. I won't get into the submissions made by the parties, but essentially the Supreme Court did decide that parties can choose, two Indian companies or individuals can choose a seat outside India. There was some discussion on the close connection test, but the Supreme Court said the close connection test is only applicable when a seat is not expressly picked by the parties in the clause. There were discussions on the definition of international commercial arbitration under section 2 subclause 2 and 2 subclause 1 subclause F. And I think one of the key things is the Supreme Court said for Indian parties to pick a foreign seat and then enforce the key ingredients of section 44 is firstly, basically, the fourfold. Firstly, dispute must be commercial dispute under the laws of India. Secondly, the dispute must be in pursuance to an agreement in writing. So it has to be written arbitration clause. Thirdly, the arbitration must be conducted in a country which is a signatory to the New York Convention. And I'm guessing that also includes the reciprocal sort of reservations that India has. And lastly, the dispute that arises must be between persons without regard to the nationality, residence, or domicile. And basically, there is freedom of contract and public policy. So there is no clear and undeniable harm caused to the public if the court or the government permits two Indian nationals to avail of a challenge procedure in a foreign country. Because obviously, as you know, if the seat is outside India, then any annulment or challenge proceedings have to be instituted in the place where the seat is. And I guess lastly, the Supreme Court said, two Indian parties opting out of Indian substantive law is not against public policy. And there were discussions about the Contract Act, but the Supreme Court said that the Contract Act does not prohibit Indian parties from selecting a foreign seat. So I guess with sort of that background, I'm going to stop sharing my screen. So let me come to you, Pramod, first. So we've had this, I guess, in a way, I guess, a watershed decision from the Supreme Court. But what was really stopping Indian parties, whether it's companies or individuals, from picking a foreign seat earlier?
I think that's a very good question. And, I think before this judgment was handed down by the Supreme Court, I think this was a much queried issue. I think a lot of international arbitration institutions have probably sought legal advice on this issue. And a lot of foreign international law firms have sought advice from Indian practitioners on this issue, simply because there was perceived to be either a lack of certainty or an element of risk in two Indian parties agreeing to choose a foreign seat of arbitration. In some respects, I would say that the controversy was an unnecessary controversy, because the issue, to my mind, was settled by a 1999 judgment of the Supreme Court in the Atlas export case. There was a previous challenge to the enforcement of an arbitration award in India. And one of the grounds that was raised before the Supreme Court was that the arbitration was between two Indian parties. The seat of arbitration was an offshore seat. This was contrary to Indian public policy, and on that basis, the award should not be enforced. And that contention was repelled by the Supreme Court, which did not see any prohibition in law for two Indian parties to choose an offshore seat of arbitration. So the controversy should really have ended there. So, if you are looking back at this issue, I would say that the history of this issue can be categorized into the good, bad, and the ugly. So the good was the decision of the Supreme Court in the Atlas export case. The bad element came in through a judgment of the Bombay High Court in a case called ADR Mercantile, which ruled that it is contrary to Indian public policy for two Indian parties to choose an offshore seat of arbitration. It is bad in law because it did not refer to the decision of the Supreme Court in Atlas Export, which was binding on the Bombay High Court under Article 141. So it was bad in law, it was per incuriam. And I would say that there is also an ugly judgment which compounded the matter. I would say ugly because it created an unnecessary element of uncertainty, and the court went into a lot of issues which was not really necessary for the determination of the case. And that is the judgment. I wouldn't call it a judgment. I would say that the decision in TDM versus UEDI. Just to clarify, TDM versus UEDI was not a judgment of the Supreme Court. In terms of the law as it stood then, this was a decision of a designate of the Chief Justice who was called upon to appoint an arbitrator. And at that point in time, this was considered to be an administrative decision, not a judicial decision. So TDM versus UEDI was not a Supreme Court judgment. It did not have the effect of binding precedent. Unfortunately, I think it was a poorly argued case. It was a poorly reasoned judgment as well. The court approached it on the basis of income tax principles, which I don't think are really applicable in an international arbitration context. And the judge overextended the scope of those proceedings, and in fact ignored some provisions of the Arbitration Act. So the question before the court was whether an arbitration between two parties, which both of which were incorporated in India, but the control, the central management and control of one of those entities was being exercised outside India, whether that would amount to an international commercial arbitration. And it was relevant because if it was a domestic arbitration, the appointing authority would be the Chief Justice of a High Court or his designate. Or in the case of an international commercial arbitration, then the appointing authority would be the Chief Justice of India or his or her designate. And that's the question that the court was asked to answer. And the court, in a sense, nullified the language of the statute. 21F expressly provided, of course, it was amended in 2015, but prior to amendment, it provided that a company whose central management and control is exercised from a place outside India would be deemed to have an international flavor, and the arbitration agreement to which such an entity was a party would therefore be considered to be an international commercial arbitration. And for whatever reason, the court held that incorporation is determinative despite what the statute provided, and said that in any circumstance, an arbitration between two India incorporated entities, irrespective of where their central management and control was exercised, would always be a domestic arbitration. So this was the good, bad, and ugly before PASL versus GE. There was, however, a good judgment of the Madhya Pradesh High Court in the Sasan Power case, where the Madhya Pradesh High Court applied Atlas Export and held that it was permissible for two Indian parties to choose offshore arbitration. And this was not contrary to public policy. There was, however, no authoritative pronouncement on this particular issue by the Supreme Court, because when the matter went to the Supreme Court decided the case on a slightly different basis. It concluded that, because there was a certain novation of contract, etc., a third party had entered into the mix. The third party was a foreign incorporated entity. And since the contract now had an international flavor, it was not really required to answer the question as to whether two Indian parties could validly choose to arbitrate outside India. So this was the context within which the issue had to be determined. And contracting parties would always hesitate to opt for a risky choice. So given the fact that at least one Indian High Court had invalidated the choice of a foreign seat for an arbitration involving two Indian parties, I think most people would have treaded on the path of caution and chosen to have a domestic seat of arbitration for all those disputes. That's no longer the case. I think the party autonomy has been upheld. And now with the welcome clarity provided by the Supreme Court, I think the position should be fairly clear. That's not to say that the Supreme Court judgment does not have its own flaws. And I'm looking at Shaneen here because she was very, very closely involved with it, and she can tell us a lot about it. But there are probably one or two wrinkles in the judgment, which I look forward to discussing with her in greater detail.
Thank you, Pramod. We'll definitely get to the wrinkles, I think. But I think that was quite helpful in terms of the background. Just coming to you now, Shaneen, I guess you've obviously been very closely involved. Can you tell us a little more about the entire controversy on the definition of what is an international commercial arbitration under Part 1, Part 2? And is that basically addressed now if parties were to pick a foreign seat?
Okay, so after the TDM ruling, I'm actually going to take off from where Pramod left off, because the TDM case was one of the cases cited most often to say that because of TDM, parties are two Indian parties. Also explained why that is not exactly what TDM said. But because of the confusion that was caused by TDM, there was an amendment made to the Arbitration Act in 2015, which slightly amended the definition of what an international commercial arbitration was. And I am just going to, that was in section 21F of the Act. And 21F originally, which defined international commercial arbitration, included within a company which was managed or controlled outside India. And in TDM, what the court decided was that the place is what is relevant, and that therefore the moment a company is incorporated in India, irrespective is a wholly owned subsidiary of a foreign company, or it may be in that sense controlled or managed outside India, the arbitration would be, and my video has frozen. Can you all hear me?
I can hear you, yeah, but I think the video's been frozen.
Okay, would you all mind if I just stopped it for 2 minutes? I don't know whether we've been having some bandwidth internet issues today.
Yeah, that's fine.
So forgive me, I'm just going to keep my video off.
That's fine.
So that portion of section 21F was actually deleted in the 2015 amendments. Now, in interpreting the word, the phrase I'm going to use the acronym ICA, is used. It's used in part 1 of the arbitration, which is seated in India and has provisions covering the entirety of the procedure. So that includes appointment of arbitrators, seeking interim reliefs, challenge and enforcement of domestic awards. The phrase is also used in part 2 of the Act when you are talking about enforcement of a foreign award.
Yeah.
Now, what Justice Nariman clarified over here, what was argued by PASL was because part 2 of the Act, when it is referring to enforcement of a foreign award, it uses the phrase ICA, commercial arbitration. You must read it to have this part 1. And this is a very legal point. What Justice Nariman said is that in part 1, when the phrase ICA is used, it includes nationality of the parties as whether the arbitration will be ICA. Only Indian parties, it is the domestic arbitration. So, Vishwam, am I audible?
You're breaking up, Shireen, I think. You're audible, but it's breaking up in the middle. Do you think it'll be helpful if you just log off and then log in? Yeah, definitely audible. It just breaks up in the middle.
Okay, let me do that. Okay, just hang on. Is this better now?
Yeah, I think it's better, slightly better. Thank you.
Okay, let me just finish this point and then when you go to log off and log back in again. Therefore, what Justice Nariman said is that when you're considering ICA for the purposes of a foreign award, of parties is irrelevant, and that is very critical because the definition of a foreign award and whether an award is enforceable under part 2 of the Act, the only thing you need to look at is territory. The nationality principle is irrelevant. You only have to look at whether the award was passed in outside India, and then the other seat is a signatory to the New York Convention. And the third, which is very unique to India, is also whether the central government has notified that territory as a reciprocating under the New York Convention. So therefore now today, if you're looking kind of foreign award is enforceable in 168 countries which are signatories convention. India has only notified about 49 of those countries. So if the award has not been passed in a seat notified by the central government in the official gazette, it is not enforceable. That is where the argument of international commercial arbitration actually came in. But if you permit me, there are a couple of interesting issues which led up to this which, if you give me the liberty, maybe, and that is the award arose out of a settlement agreement. The parties had another agreement under which disputes arose that was settled, through a settled agreement which contained the arbitration clause you referred to. The arbitration clause did not actually provide for Indian law. That was agreed to by the parties during the course of the arbitration. During the course of the arbitration, in fact, GE argued the point on jurisdiction as a preliminary issue that two Indian parties could not arbitrate in a foreign seat. And the reason for the massive claim that was made against us, we had no counterclaim, and we were a little wary of having to then challenge the award in a foreign seat. So, and I could see Pramod smiling in the arbitration on that. Of the parties challenged this, and the arbitration continued. Things then turned around on their heads so that PASL actually filed a Section 34 application before the Gujarat District Court, challenging the foreign award in India and arguing that two Indian parties could not have a foreign seat. And on the other hand, applied for enforcement, arguing to the contrary. So this is just, and what was
sorry, I think you're really breaking up.
Only a costs award. So
you're breaking up a lot now.
Okay, I'm sorry, I'm handing over to Pramod. Sorry, I'm handing over to Pramod now, and I will come back later.
And sorry for that. Thank you, Shaneen. Pramod, did you have anything? Did you just want to continue where Shaneen left, or should we move on to like the next sort of segment?
We could probably go into the next segment, and we can probably have a round of further observations, if any, if there are any points left unsaid. I'm sure that's unlikely to be the case. I'm sure you've got a comprehensive set of themes to cover during the discussion today.
Okay, thank you, Pramod. I think the next theme I wanted to sort of discuss, and this is probably very relevant, I think, generally for the CI members. Some of them are on this call, some of them are attending on YouTube, but obviously a recording is going to be sent to most of them, is basically drafting an arbitration clause with a foreign seat. I'll come to why that should happen and why would Indian parties want to pick a foreign seat. But leaving that aside, if you assume that Indian parties were to pick a foreign seat in their contracts, how do you think they should go about drafting the arbitration clause? Is there anything different from saying, having Delhi or Bombay a seat vis-a-vis now having Singapore or Dubai or Hong Kong seats? How would you advise them to basically say, these are the factors or these are the things you should take into consideration when you pick a foreign seat in an arbitration clause?
Well, I think the general guidance would continue to apply in these cases, which is institutional arbitration is almost always better than ad hoc arbitration. And if you pick the recommended arbitration clause of your chosen institution, you're unlikely to go wrong. So, I think those two guiding principles for drafting of any arbitration clause would continue to apply in such a context. And I don't think they should really, especially after this judgment, I don't think that there are any specific tweaks that need to be made when you have a situation of two Indian parties agreeing to choose an offshore seat of arbitration. But I think, nevertheless, contracting parties should consider as to why they would need to have a foreign seat of arbitration. I think some of those reasons could be, for instance, one, it's perceived that Indian arbitration is slow and an offshore arbitration would be expeditious, relatively speaking. Things have changed in India since the 2015 amendments and the introduction of definite timelines for conclusion of arbitration proceedings. That's one. The second aspect, another pull factor for offshore arbitrations is that you have access to a deeper pool of arbitrators as compared to arbitrations in India, which are still largely dominated by retired judges, some of whom are excellent. Nothing that I say should really be interpreted as saying that they are not good arbitrators, but in many cases, parties may choose to have a more commercial mind, to handle fairly complex and specialized kinds of disputes. So you may need to have an energy expert to decide an LNG dispute. You may wish to have a construction specialist to decide a construction dispute, etc. And that pool of talent may be more easily available outside India as compared to what is available onshore. The third reason could be the perception of the Indian courts being interventionists when it comes to considering challenges to arbitration awards. And there is also the related element of delay. Some Indian high courts or some Indian states are faster at deciding arbitration cases. I would say, for instance, the Delhi High Court is one of the quickest in the country in its treatment of arbitration-related matters, whereas high courts and district courts in other parts of the country are probably not as quick. Also, given the ambiguity relating to the interpretation of public policy, which in a case of arbitration seated in India could also be a disguised appeal. There may be a perception that the courts in an offshore jurisdiction are likely to be less interventionist when it comes to considering challenges to arbitration awards. So these may be the draws of parties choosing an offshore seat. And given the fact that Indian parties would now have access to all those perceived benefits of a foreign seat, but also not be deprived of access to the Indian courts, either for enforcement or for access to interim remedies, I think it's probably a decision which has made offshore arbitration more attractive for Indian users of arbitration.
Thank you, Pramod. I think that's quite helpful. I can see Shaneen is back. Shaneen, so we've sort of moved on to the next segment in terms of drafting the arbitration clause. And it's particularly relevant, I guess, because if the CII members, domestic Indian companies, would pick a foreign seat, how would we go that? So I think Pramod's very efficiently told us what are the benefits or the pros of picking a foreign seat. I just wanted to come to you on what you think the impact would be in terms of, so if you were to pick a foreign seat in terms of, choice of law, enforcement, whether the reliefs available to the parties are better off, and how that would play out in practice.
So I think I came in the middle of what Pramod was saying, so I may overlap a little bit. Firstly, I think this ruling is not going to be a kind of watershed where every Indian company is going to want to arbitrate outside. There are pros and cons of both. I think this judgment is going to be most welcome to those companies such as GE, for instance, which are multinationals and by virtue of their trade or investment in India have had to set up wholly owned subsidiaries. So it is those companies who will most want a foreign law or most want a foreign seat. So let's be clear on that. I don't think there is a huge amount of logic for two Indian companies where the cause of action, their residence, their assets, everything is within India. I don't think it really makes much sense for them to arbitrate outside. So if everything is in India, I, as a lawyer, would recommend an Indian seat. So having said that, let's look at some of the reasons why you may choose a foreign seat. And I think the biggest reason is because of the time that it may take to decide any court proceedings, or most importantly, challenge to an award. If you look at all the recent decisions of the Supreme Court, or most, you will find that our courts are very robust. There is a very narrow scope of review to an award. And by and large, I would say 90 to 95% of the time, a well-reasoned award will be upheld. The biggest problem is really the delay. So it is really because if you have assets offshore and you're looking at enforcing offshore, or you are a group company which is based offshore, that you may particularly want to have an offshore seat. Let me also clarify that this judgment actually stops short of giving carte blanche to foreign governing law. If you look at the ruling, Justice Nariman seems to go almost there but stops short. It is still risky for Indian parties. They may arbitrate in a foreign seat, but can they contract absolutely out of Indian law and mandate a foreign governing law to their contract? I'm not so sure. That is still risky. Justice Nariman has not gone into that issue, and that would be said to be contrary to public policy. So really, I'm going to give you a lawyer's answer. Would parties arbitrate outside? It really depends. The benefits, and I know I'm going to overlap with what Pramod has said. The benefits, of course, would be that two Indian parties arbitrating outside, they don't have the patent illegality challenge available to them. I think I did hear Pramod say that. But on the flip side, an award passed in India is automatically executable as a decree. And this is what Justice Nariman referred to as two parties arbitrating outside will have two bites at the cherry. One, to challenge the award in the foreign seat, and two, to oppose enforcement when it is brought here to be enforced. Whereas if you arbitrate in India, there is only one bite at the cherry, which is your challenge or your set-aside application. So there are pros and cons both ways. I don't think there is a definite preference dehors the status of the parties and the facts of the case.
Thank you, Shaneen. I think that's quite helpful. Just coming back to you, Pramod, you mentioned institutional arbitration is you would recommend institutional over ad hoc, whether the seat is in India or abroad. If parties were to pick, say, an Indian arbitral institution, but a foreign seat, do you foresee any problems with that? You're on mute, sorry, Pramod.
So sorry, Vishwam. I assume the question that you're asking me is there a distinct benefit in parties choosing Indian institutional rules but a foreign seat? Is that the question?
Yeah.
Okay. Well, I think from an enforcement perspective, it shouldn't matter, because enforcement is seat specific and not institutional rules specific. So whether you choose SIAC arbitration in Singapore or MCIA arbitration in Singapore, the resulting award at the end of the process will always be a New York Convention award, which can then be enforced in India or in any other jurisdiction under the provisions of the New York Convention. So, I think it is something which, the parties will consider. And I think Shaneen made a very good point. Parties would look long and hard at what their contract is and what kind of disputes could arise. And if there's a perception, for instance, that SIAC arbitration may be a little more expensive in case of a low to medium value dispute, then the parties could choose, for example, the rules of an Indian institution where the fee schedule is a lot more modest. But they would still have access to the beneficial regime of Singapore as a seat of the arbitration. They would also have access to the New York Convention for enforcement of the award, should such an award have to be enforced outside Singapore. And therefore, these are probably considerations that would weigh in the mind of contracting parties when choosing firstly an institution and secondly the seat of the arbitration.
Thank you, Pramod. That's quite helpful. I think just sort of moving on, I guess, in sort of helping decide, I know Shaneen mentioned that she wouldn't recommend to purely Indian businesses from picking a foreign seat. But if I were to, create a hypothetical situation where two Indian companies with or without foreign assets, Indian businesses, so not, subsidiaries of international companies, but Indian businesses, maybe with potentially some assets abroad, but mostly in India, if they are looking to arbitrate between India and abroad, pick a seat in India or abroad, how would you advise them to basically, mitigate their risks and do it in the most cost-effective manner? For instance, would you say, you can have a clause which says the seat is abroad, but the venue essentially you can just conduct proceedings online, so nobody really needs to travel anywhere, not even designate a seat in India, because you can just have an online hearing and online proceedings. So how would you sort of advise on that? If I come to you, Shaneen, first on that.
Okay, so yes, of course, a cost mitigating measure is to have a venue that is closer to home. So you save on your travel costs for not just the parties, but also the arbitrators, if the arbitrators are also within your jurisdiction. Irrespective of where your venue is and irrespective of whether you decide to have the entire arbitration conducted online, it is imperative for you to designate a seat.
Of course.
Because the seat will determine which courts have jurisdiction over the arbitration proceedings and which courts will be the courts which you may approach to challenge your award. Of course, in terms of interim relief under Section 9 now, whether you have an Indian or a foreign-seated arbitration, you are entitled to approach Indian courts for interim relief. So that is irrespective. So I am not going to touch upon whether we would choose a foreign seat or an Indian seat, really. But what are the various cost mitigating measures that you can put in? Of course, would be that if there is a foreign seat, you have a venue that is local or easier or more cost effective to go before. That would of course mean, so for instance, going back to the PASL-GE ruling, although the venue was in Zurich, we had some of the parties in Delhi, some of us were in Bombay. The arbitrator was from Geneva, and it just made more sense logistically and from the point of view of costs to have the arbitrator travel to Bombay and have the other side travel from Delhi to Bombay, which is why witnesses were also spread across India. But so that is one contained costs, and that is fairly common. The other is to have, and I think the COVID situation, which has given rise to these kind of platforms being used very often, is also going to result in a considerable amount of cost and time efficiency, because you will see that more and more procedural hearings, maybe short jurisdictional applications or interim applications, will also be heard online. As a result of which you can save the physical travel for perhaps your witness cross-examination and or your final arguments at the final stage. So these are other cost mitigating measures that you can put in mind. I want to just, many clients ask us to evaluate the costs of various institutional rules. Should we choose CAC? Should we choose MCIA? Should we choose ICC? One needs to understand that the costs of the institution are actually a very small part of the arbitration. The larger part is the arbitrator's fees. And now whether of course, whether Pramod is sitting as an arbitrator before CAC or MCIA or ICC, his fees are likely to be within the same range. So there is not a huge amount of difference. There is a huge amount of difference if you look at some of the Indian domestic institutions, say I won't mention names, but some of their fees are quite low. But what you then find is that busy arbitrators like Pramod don't find it worth their while to sit for those kind of arbitrations where the fees are very low. So you see, it all evens out. Even your institutional fees are not going to be what is going to result in a great amount of differential. It is going to be your arbitrators choosing a senior or a junior arbitrator. choosing a 3-member tribunal or choosing a sole arbitrator. For simple, less complex disputes, of course, it makes sense to choose a sole arbitrator. If you feel that parties may not be able to agree, then the institution may appoint the arbitrator. You decide whether you want to have an expedited procedure, whether you want to have a document-only hearing or expedited procedure. Again, where witness evidence is required, it stands to reason that document-only arbitration will not work. But these are the various cost mitigating measures that can be put into place. It depends, of course, and you're going to look at it at the time of drafting your dispute resolution clause. But for instance, I would never put into a construction contract a document-only arbitration. I may, however, if it is in relation to the Microsoft license I have purchased for my office. So again, the answer is it depends, but these are some of the ways you can put some amount of cost savings and efficiency.
Thank you, Shaneen. I think you covered the cost element very well. Pramod, just the same question to you. If you could, I guess, look at the non-cost risks more in terms of, I guess, the legal risks and everything, how you would advise on that and how people can sort of mitigate and preempt that. You're on mute again.
Thanks, Vishwan. I echo everything that Shaneen had so very eloquently captured, except for the fact that, she kind of alluded to the fact that I'm a busy arbitrator and sometimes an expensive arbitrator. I'm neither. So let me start with that caveat.
I'll hold you to that, Pramod. I'll hold you to that.
But I think in terms of the various considerations, I think one option is for parties to choose a foreign seat, but choose an Indian venue, which is quite common, and I think it's a well-used formula in recent times. But just sticking to the cost element, I don't think it's cost as much as it's costs, it's convenience. And it's probably also, something which appeals to people's green conscience. I think over the last 13 odd months, I have not done, I think, except for one, I have not done a single physical hearing. All hearings, whether it's a procedural hearing, an evidence hearing, or oral submissions on interim measures of protection, etc., all of them, whether it's a domestic arbitration or an international arbitration, have all happened online. So I think that the changes that we have seen are going to be probably far-reaching, and it's going to outlive the pandemic. It is not something that will probably come to an end, with the ending of the pandemic, whenever that is. I think these are fundamental seismic changes which has changed the way we practice arbitration. And that's only a good thing. But in terms of the various other options that parties may look at, so cost is one aspect. The other aspect is that, and I'd be very interested in hearing your views on it. Can, for example, so Shaneen mentioned a very important point, which is a lot of multinational corporations which invest in India may need to incorporate a vehicle here. But in terms of their standard dispute resolution policies, the standard guidance would be to arbitrate offshore if they have that option. And one important reason for that is that many of these multinational corporations have panels of law firms who have traditionally advised them on a wide range of matters, and they would continue to advise them on arbitration seated outside India. So one question, and I think this is going to be a bit of a gray area, but I'll be very interested in hearing your views, is if two Indian parties agree to arbitrate outside India, and probably one of those parties could be the Indian subsidiary of a company like GE or any other conglomerate, but the substantive law of the arbitration is Indian law. Would foreign law firms be entitled to appear before an arbitral tribunal, or would this fall foul of the Supreme Court's judgment in the A.K. Balaji case? And if such, if, for example, a foreign law firm were to appear in such a matter, would an Indian court refuse enforcement of such an award on the ground that it's contrary to public policy?
I'm not sure if the question was for me or for Shaneen, Pramod.
I'd be very interested in hearing both your views and in fact, anyone else on the panel too.
Do you want to go first, Shaneen?
I'm happy to go first, but I'm certainly not going to be able to give an answer to Pramod. This is, of course, a very vexed question. Our government has constantly promised an opening up of the legal profession. In my view, I don't think there should be a problem, particularly in terms of arbitration, but I think a lot will depend on the kind of judge you come up before. Even the PASL ruling, had we come up before a very conservative or technical judge, the decision could have gone a different way, and a judge could have held that this is opposed to public policy. So to be honest, I don't have an answer for Pramod.
Thank you, Shaneen. To be honest, I think it's a very interesting question, Pramod. I would agree with Shaneen to the extent that I don't have a definite answer, but I would imagine that if you have a foreign seat, whether it's Singapore or Dubai or Hong Kong, obviously that would involve an element of foreign law, not on substantive, not on the merits, but at least on the things that have to do with the law of the seat. In which case you may have a mix of Indian lawyers as well as Singapore qualified or Dubai or Hong Kong experienced lawyers working alongside Indian lawyers, and that may obviously have different connotations in terms of it being more expensive to begin with. But I can certainly see that there could be situations in which if the Indian lawyers, the main lawyers, they would work alongside foreign counsel to the extent that you need advice on Singapore law or Hong Kong or DIFC or whatever the seat is, for instance. I don't know if anybody from the audience has any thoughts or comments on that. No, okay. I'll move on. I know Shaneen has a hard stop at 6:30. So Shaneen, before you go, I think it'll be interesting to discuss what Pramod mentioned briefly as the wrinkles in PASL versus GE judgment. If you can sort of elaborate on that a little bit.
Okay, so I don't know what Pramod was specifically referring to. So I will, of course, allow him to clarify. But the only wrinkle, I think, first of all, I have to confess that I am a big fan of Justice Nariman. I think he has, before he retires in August, I think he's determined to set straight as much law as is possible. And in fact, it was very clear because when we came up before him at the admission stage, that was in Feb, and this ruling came in April. So you can see how fast he moved. I wouldn't call it a wrinkle. I would call it an ambiguity. And that is what I alluded to in terms of whether these two Indian parties could mandate a foreign governing law to their contract. And as I said, if you read paragraphs 51 to 53, and I think about somewhere around 91, you will see that he has dealt with the foreign law issue, but not categorically given an answer one way or another. And that is where it is left open. Now, if you read the provision of the Act, which is constantly relied upon to say that Indian parties could not have a foreign seat, that is Section 28, which says that in an arbitration which is not an international commercial arbitration and which is being decided in India, the governing law, the dispute shall be decided in accordance with the substantive law of India, which means Indian governing law. Now here you have said that this is an arbitration outside India. Therefore, Section 28(1), this provision does not apply. Therefore, there is no preclusion, at least in the Arbitration Act, to two Indian parties having a foreign seat and then being permitted to apply foreign law. So while there is no preclusion at all in the Arbitration Act, you then fall back in the Indian Contract Act to see whether this would be a contract that was illegal or opposed to public policy. Is contracting out of Indian law opposed to policy? Now, the Supreme Court has not weighed into this, and which is why I say there is some ambiguity left over there, and that is why I also said that this might still be risky. I believe, in my view, it should be permissible. Of course, where Indian law mandatorily applies, so for the extent you will still be bound by FEMA, you will still be bound if you're a company incorporated in India, you will still be bound by taxing statutes, you will still be bound by the Companies Act, and everything else that covers you by virtue of your incorporation in India. But your dispute may be decided under foreign law. So I think that is where there is an ambiguity. I don't see any particular anything else that gave me any real cause for concern in this judgment. But I mean, I don't know, since I succeeded in it, I don't know whether I've worn rose-tinted glasses. Pramod can add to what I've said.
Pramod?
So a couple of wrinkles, but before coming to that, my reading of the judgment is I think the court made a very clear distinction between choice of seat and choice of law. The full expression of party autonomy, including the right to choose a foreign seat of arbitration, was upheld in the context of choice of seat. But as far as choice of law was concerned, I think the court cited Cheshire on private international law and said that the apprehension that two Indian parties would choose a seat of a foreign seat of arbitration in order to circumvent the application of, let's say, an enactment like of an inconvenient enactment like the Benami Prohibition Act, etc. The court discussed that specific instance and said that that's unfounded because the arbitrator would still have to apply mandatory rules of Indian law in accordance with principles of private international law. So where as per private rules of private international law, the tribunal has to apply Indian governing law either because the parties have made a choice of Indian governing law or Indian law has the closest connection to the dispute, then the arbitral tribunal would be bound to apply rules of Indian law and cannot, for instance, decide the matter in accordance with the rules of, let's say, Macau or Hong Kong or any jurisdiction that the parties may have chosen for themselves. So I think that much is clear. But the two areas where I think there are wrinkles in the judgment is, I think there is probably this is more conceptual rather than practical, but the second is practical. The first one is where the court seems to suggest that there's a clear segregation of Part 1 and Part 2 of the Arbitration Act. And in support of that, what the court does is it cites BALCO. What the court did not recognize in the judgment is that BALCO has been overridden by legislative intervention. BALCO decided that Indian courts could not intervene in relation to arbitration seated outside India. It could not order interim measures of protection in respect of arbitrations happening outside India. It could not constitute a tribunal when there was a deadlock between the parties in relation to constitution of a tribunal. And it certainly could not do what it had done previously in Venture Global versus Satyam, which is exercise powers under Section 34 in relation to arbitration seated outside India. So that's what BALCO decided. So BALCO did say that there was, in fact, two separate codes and never the twain shall meet as far as Part 1 and Part 2 is concerned. However, that meant that parties to an offshore seat would not have access to interim measures of protection from an Indian court. And that's when Parliament legislated in 2015, crafted an exception in Section 2.2, for instance, to say that even in cases where the seat of arbitration is outside India, the Indian courts can intervene. So the powers of the courts under Section 9 under section 27 in relation to interim measures or in relation to taking of evidence, etc., can still be available even in respect of arbitrations that happen outside India. So I think conceptually, I think this conclusion is probably questionable. The more important aspect is I believe that the Gujarat High Court had got the law right in saying that whilst there is no prohibition in respect of two parties choosing a foreign seat of arbitration, given the language of the statute, in such a situation, the Indian courts would not have the power to grant interim measures of protection. Because post-Balco, the Indian courts could not grant interim measures of protection in respect of arbitration seated outside India, irrespective of who the parties were. The rule was liberalized in 2015 by Parliament enacting an exception. And the exception says that in respect of international commercial arbitrations happening outside India, the powers of the court under Section 9 would be available. Now, an international commercial arbitration by definition is one where at least one of the parties has a foreign nationality. So where two Indian parties agree to arbitrate outside India, it would not constitute an international commercial arbitration. And therefore, in terms of the exception to Section 2.2, the Indian courts would not be able to order interim measures of protection. And this is one area which I think is under-analyzed in the judgment. I think the reasoning of the Gujarat High Court on this was fairly exhaustive and detailed. Whereas in the Supreme Court judgment, I think there's probably one sentence which deals with this issue. And I think there's clearly a problem there. I think it would be unfair to say that two Indian parties can arbitrate outside India, but they would not have access to the Indian courts for interim measures. There is a problem there. But that problem, I would imagine, is for the parliament to fix and not for the courts. So absent any clear legislative mandate, I don't think the Indian courts could have really said that even in cases where two Indian parties arbitrate offshore, they would have access to the Indian courts for interim measures of protection. And for me, that is the real wrinkle in the Supreme Court's judgment. I'm sure Shaneen has a different view.
I do, and I was just going. I need to drop off. Sorry, if I can very quickly respond to Pramod. And it really depends, right? Lawyers can argue both sides of any case depending who they are representing. But just very quickly. When you look at the exclusivity of part 1 and part 2, sorry, you'll have to forgive the dog as well. The provision for interim relief, which was brought in pursuant to Balco, is not something that is available in part 2 of the Act. Part 2 of the Act relates to foreign awards, enforcement of foreign awards, and referring parties to arbitration where there is a foreign seat of arbitration. That's it. Part 2 does not deal with anything else. So to that extent, it is exclusive of part 1. Therefore, the provision for interim relief, which provides recourse to Indian courts for interim relief or court assistance in evidence, has no relation to the provisions in part 2. So therefore, I believe that Balco and the mutual exclusion of part 1 and 2 can still be read in that fashion. Insofar as the ICA point that Pramod is making, I think what Justice Nariman has done is done justice, which Pramod says that, of course, this is then a lacuna in the Act. So Justice Nariman has been able to fashion the ruling so as to do justice and not leave these parties without recourse, something that Justice Haryawa tried to do in Bhatia International, but was then castigated for, and then Balco overruled Bhatia International. I think that argument can be, I see the logic of the Gujarat High Court. I see the logic of Justice Nariman. And of course, I mean, we spent a lot of time looking at the New York Convention and the way it was interpreted, as also the Trevor preparatories, which is how we fashioned this argument. But I agree with Pramod to the extent that it could be interpreted both ways. And with that, apologize to everyone. It's been great to see you all, but I will have to drop off. So please forgive me, and thank you very much for allowing me to participate.
Thank you so much, Shaneen. Thanks a lot.
Always a pleasure to hear you.
And you, Prabhu. Bye then.
Thank you, Shaneen. Bye. Pramod, we've got one question from the audience. I think Rumani is asking, the perception of delays in dealing with court proceedings is the main or the biggest deterrent for domestic parties. If you want to share any views on what can be done and what is being done to address this, I guess probably like an evergreen question. But if you have anything you can share.
Sure. I think a lot can be done by proactive counsel. The biggest delays are at the stage of a challenge to an arbitration award. And earlier, the position of law was that the moment there's a challenge to an arbitration award, the award gets consigned to cold storage. And it is only when the challenge is finally adjudicated that the award is then dusted off from the cold storage, and that's when the enforcement proceedings begin. That has now been changed again by virtue of parliamentary intervention. It is now possible for you to insist that even though a challenge has been filed, in order for the award debtor to get a stay of enforcement of the award debtor will have to deposit the entire amount awarded in court, or pay it to the award holder, or provide a bank guarantee for that sum. So, and in practical terms, this is very significant because you often had unmeritorious challenges to arbitration awards being filed, simply for the reason that one, the courts would not award indemnity costs, which is not the case in many other jurisdictions when there's a challenge that is filed. And secondly, by filing a challenge, you could postpone enforcement of the award by not months, but by years. But now, the moment a challenge is filed, the challenge court can decline to grant a stay of enforcement of the award unless the award debtor deposits money or provides security. And by insisting that the entire amount or a substantial part of the amount be deposited in court, you'll find that it takes away the incentive for losing parties or recalcitrant parties to engage in an unmeritorious challenge to the arbitration award. So that's a very, very important aspect. And thankfully, now because of the amendments to the statute, a proactive approach at this stage can really shorten the time available and the incentive for parties to first mount unmeritorious challenges, and it can also expedite decision making.
Sorry,
Sorry, I was on mute. Thank you, Pramod. I think you just mentioned about the amount being deposited. I think Akela is asking if the entire amount has to be deposited or just the amount directed by the court.
Now that's discretionary for the court, with one caveat, which I'll come on to. It's discretionary because the court can decide whether it has to be 100%, whether it has to be 50%, 75%, should the amount be deposited or should a bank guarantee be given. Now, these are all areas within the realm of the court's discretion, and therefore you'll probably have to persuade the court to direct the award debtor to deposit the entire money, because that's probably the one which will pinch it the most. But there is one exception to that, and that exception has been brought in by the latest legislative amendment to the Arbitration Act, which is where either the arbitration agreement or the contract within which it is contained or the making of the arbitration award is vitiated by fraud. Then in such cases, the court does not have discretion. It has to grant an automatic stay of enforcement of the award without imposing any conditions whatsoever. But I would imagine that those would be very, very rare cases, extraordinary cases, because the party which is seeking such an order will have to make out a prima facie case of fraud. And if it had made a prima facie case of fraud or a conclusive case of fraud, the result in the arbitration would have been quite different. So it's going to be quite an uphill task for a party to make a prima facie case that the making of the arbitration award or the contract or the arbitration agreement was vitiated by fraud.
Thank you, Pramod. I think just to add, Akela, I think in the last webinar in April or May edition, we discussed the Supreme Court decision as well on this issue. Whereas I think the district court had said X% and then the High Court had reduced it by exercising its jurisdiction, and the Supreme Court said the High Courts can't do that. So I think the recording is probably there on YouTube, but there's a recent Supreme Court decision which delves into this in quite detail, which we discussed recently. I can see there are no other questions. So I'm just going, sorry, if you give me 1 minute.
Sorry, sir, to interrupt in the middle. Actually, one of the participants messaged me the question personally. So,
okay.
Am I allowed to speak up?
Please.
Yeah, thank you, sir. So the question is, during the stay of award, whether interest accumulates on the awarded amount?
I think in terms of the CPC rules, if the amount is deposited in court, then interest stops accruing. The clock stops, as it were. However, if a bank guarantee is given, then of course the interest will continue to accumulate.
Thank you, Pramod. I guess if there are no other questions, I would just like Chaitanya to thank Pramod, and then I can just deal with some housekeeping issues.
Thank you, sir. On behalf of Team Corporate Law Advisor and CII, a special thanks to you and to Shaneen ma'am, who had to leave the meeting earlier, unfortunately. But thank you both of you for speaking in this session and discussing a very important issue and discussing the PASL judgment in detail with its wrinkles. And we hope that we are able to answer all the queries of our participants. So over to Visham, sir. Thank you.
Thank you so much again, Pramod. And I know Shaneen's left, but it was an absolute pleasure to hear both of you. And I'm sure everyone attending and everyone who's going to watch the video later would definitely learn a lot from our discussion today. Just in terms of housekeeping, a recording is going to be there on YouTube. And if any of you need copies of the slides or anything, please feel free to email me. Otherwise, I look forward to seeing you on the July edition of the webinar, which is on the last Friday, as always, at 5 p.m. Thank you so much.
Thank you very much.
Thank you.
Bye for now, everyone.
Thank you. Stay safe.
Thank you very much.